All right, let's dive right into something called intentional torts. Now, this isn't about slip and fall accidents. Oh no. We're talking about those times when someone intentionally crosses a line, violating your rights to your own body, your stuff, or even just your peace of mind.
So let me ask you this. Have you ever had someone pull a chair out from under you as a prank? I think we've all seen it happen, right? You're about to sit down and boom, you hit the floor. Is that just a bad joke, or is it actually something more? Well, the law of torts gives us a way to figure that out.
Okay, so what in the world is a tort? Honestly, it's pretty simple. A tort is a civil wrong. The key word there is civil. We're not talking about crimes where the government comes in and prosecutes somebody. Nope. This is about disputes between people, where one person's wrongful act causes harm to another, and the courts can step in and provide a solution. Usually that means money.
Now, here's what's so cool about this. Most of these intentional torts, they're all built from the same three basic pieces. It's like the legal DNA of a wrongful act. And once you get this simple structure, the whole system just clicks into place.
And here they are: act, intent, and causation. That's it. First, you need a voluntary act, a conscious movement. Second, you have to have intent, and this is a really big one we're going to dig into. And third, causation. The act actually had to cause the harm. See? Pretty straightforward.
So let's really zoom in on intent, because this is where a lot of people get tripped up. In tort law, intent doesn't mean you have to be this evil, malicious person. Not at all. It just means one of two things. Either you wanted to cause a certain result, or you knew with what the law calls substantial certainty that your actions were going to cause that result.
Think of it like there are two different roads to get to intent. On one side, you've got specific intent. That's your purpose, your goal. It's basically you saying, I meant to do that. But on the other side, you've got general intent. This is all about knowing a result is pretty much guaranteed. It's like saying, well, I didn't want her to fall, but I knew she would when I pulled the chair. And guess what? Both of them count as intent in the eyes of the law.
And that brings us right back to our chair-pulling prank. This exact phrase, with knowledge that such contact is substantially certain to be produced, it comes from a super famous case, Garrett v. Daly. It was about a 5-year-old boy who pulled a chair out from under his aunt, and the court basically said, look, even if he didn't want to hurt her, if he was old enough to know with substantial certainty that she was going to try and sit there and would fall, then he had the intent needed for the tort of battery. Wild, right?
Okay, so now that we have those building blocks down, let's see how they work in the real world. We'll start with our first big category: torts that are all about protecting you personally. This is about your fundamental right to be left alone and not have your physical self messed with.
First up, we've got battery. Now, we all think of battery as like a punch in the face, but it's actually way broader than that. Take the case of Cohen v. Smith. This shows that battery can be an offensive contact, not just a harmful one. What happened was, a patient told her doctor she had a religious objection to being seen or touched by a man, but during a procedure, a male nurse touched her anyway. The court said that was a battery, not because she was physically injured, but because it violated her known personal dignity. It's a huge point.
All right, let's clear up one of the most common mix-ups out there: assault versus battery. They are not the same thing, okay? Assault is the threat. It's when you make someone reasonably believe they're about to get hit. So if I swing my fist at you and you see it coming, that's an assault. Battery is the follow-through. It's the actual physical contact. So if I sneak up and punch you from behind, well, that's a battery, but it's not an assault because you never saw it coming. You weren't aware of the threat.
Next up, the law protects our basic freedom to move around. This is done through the tort of false imprisonment. And it's exactly what it sounds like. It's when someone intentionally traps you or confines you to a specific area against your will.
But what does confinement really mean? It's not just about locks and bars. A famous case, McCann versus Walmart, really clarified this. You don't have to be in a jail cell. Confinement can happen just through threats, like someone saying, "Don't you dare move or else." Or it can happen through a false claim of legal authority. Like a store security guard telling you you're not free to leave when they have no real reason to hold you. The restraint can be totally mental, not just physical.
Okay, now for a really fascinating, almost magical legal idea. It's called transferred intent. Let's set the stage. Imagine someone has a plan. They intend to commit a tort. Let's say they pick up a rock and they want to throw it at person A. The intent is there. The target is locked in.
But their aim is terrible. The rock sails right past person A, and instead it hits person B, just an innocent person standing nearby.
Now, the person who threw it never, ever intended to hit person B. So, does that mean they get off scot-free? No liability?
And this is where the law does its magic. The doctrine of transferred intent says that the bad intent aimed at person A, it doesn't just disappear, it transfers right over to person B. The law is basically saying, hey, you're not getting off the hook just because you're a bad shot. That bad intent follows the bad result, and it makes sure the person who actually got hurt has a claim for battery.
So those same principles that protect our bodies, they also protect our stuff. The law gives us the right to control and enjoy our own property without other people intentionally interfering.
The most famous one here is, of course, trespass to land. This is pretty much any intentional physical invasion of someone else's property. And the key thing to get here is that the only intent you need is the intent to be there. It doesn't matter if you honestly thought it was your land or you thought it was a public park. Mistake is no defense. And get this, you don't even have to cause any damage. Just stepping foot on the property is enough.
Now, what about your personal belongings, your stuff? The law calls this chattels. And here there are two main torts. I want you to think of it like a spectrum of interference. On the minor end, you have trespass to chattels. So maybe you borrow my textbook for an hour and give it back with a little coffee stain on it. That's a minor interference. But on the serious end of the spectrum, you have conversion. This is when you take my textbook and you sell it. The interference is so serious that the law basically says, you just bought that book. You owe me the full value.
And don't think these are just some old, dusty rules. They are absolutely still relevant. In one really interesting case, a court decided that intentionally flooding a company's computer system with tons of spam emails could be considered a trespass to chattels. The server was the chattel, the thing, and its normal use was disrupted. It's a perfect example of how these foundational legal ideas can adapt to brand new technology.
Okay, for our last category, we're going beyond physical harm to people and property. The law also steps in, but only in very, very specific situations, to protect us from purely emotional or psychological harm.
This brings us to a tort with a seriously dramatic nickname: intentional infliction of emotional distress. It's often just called the tort of outrage. And really, that name tells you everything you need to know. The bar for proving this is incredibly high.
To actually win one of these claims, you have to prove all four of these elements. The act has to be intentional or at least reckless. It has to have caused the distress. The distress itself has to be severe. We're not talking about just being annoyed or having your feelings hurt. But the toughest one, by far, is the second element. The conduct has to be truly extreme and outrageous.
So what does extreme and outrageous even look like? Well, the case of GTE Southwest v. Bruce paints a pretty horrifying picture. Look, a bad boss who's unfairly critical or uses some profanity, that's just an unfortunate ordinary workplace dispute. But in this case, a supervisor had a daily pattern of screaming fits, of physically intimidating employees by charging at them and forcing them to do incredibly humiliating things, like get on their hands and knees to clean the floor. That, the court said, is the kind of conduct that is utterly intolerable in a civilized community.
So, from a simple prank with the chair to a server flooded with emails to an absolute monster of a boss, tort law is really all about drawing lines. It's about protecting our rights to our bodies, our property, and our peace of mind from intentional invasion. It forces us, as a society, to decide what kind of behavior is acceptable and what's just not. And that really leaves us with a final question to think about. Knowing where the law draws its lines, where do you draw yours?